Free access to courts, Section 11, Article 3. Free access to courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. This is a social justice provision implemented by the rules of court, allowing pauper suits. Miranda Doctrine, Section 12, Article 3. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent, and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. No torture, force, violence, threat, intimidation, or any other means which vitiates the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. That's number 2. Number 3. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. 4. The law shall provide for penal and civil sanctions for violations of this section, as well as compensation to and rehabilitation of victims of torture or similar practices and their families. The rights guaranteed in Section 12, Article 3 exist only in custodial investigation or in custody interrogation of accused persons. People v. Judge Eisen, 175 Scra 216, which has been defined as any questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. The rule begins to operate at once as soon as the investigation ceases to be a general inquiry into the unsolved crime, and direction is then aimed upon a particular suspect who has been taken into custody and to whom the police would then direct interrogatory questions, which tend to elicit incriminating statements. People v. De La Cruz, GR 118866-68. In Dilatory v. Court of Appeals, GR 102786, it was reiterated that the Miranda rights apply only from the moment the investigating officer begins to ask questions for the purpose of eliciting admissions, confessions, or any information from the accused. Thus, in People v. Bololoy, it was held that this guarantee does not apply to a spontaneous statement not elicited through questioning by the authorities, but given in an ordinary manner whereby the suspect orally admitted having committed the offense. Neither can it apply to admissions or confessions made by a suspect before he was placed under custodial investigation. In this case, the narration before the barangay captain prior to custodial investigation was admissible in evidence, but not the admissions made before Judge Dicon. Inasmuch as the questioning by the judge was done after the suspect had been arrested, and such questioning already constituted custodial investigation. Under RA 7438, custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed, without prejudice to the liability of the inviting officer for any violation of law. Thus, in People v. Del Rosario, GR 127755, it was held that from the time Del Rosario was invited for questioning at the house of the barangay captain, he was already under effective custodial investigation, because he was not apprised nor made aware thereof by the investigating officers, and because the prosecution failed to establish that Del Rosario had waived his right to remain silent. His verbal admissions were inadmissible against him. In People v. Ordonio, the Supreme Court held that custodial investigation began when the accused Ordonio and Medina voluntarily went to the Central Police Station to confess, and the investigating officer started asking questions to elicit information from them. GR 132-154. In People versus Lugod, GR 136253, it was held that the accused should have been entitled to the Miranda rights because even assuming that he was not yet under interrogation at the time he was brought to the police station, his confession was elicited by a police officer who promised to help him if he told the truth. Furthermore, when he allegedly pointed out the body of the victim, the atmosphere was highly intimidating and not conducive to a spontaneous response, as the whole police force and nearly 100 townspeople escorted him there. Not having the benefit of counsel and not having been informed of his rights, the confession is inadmissible. In People versus Pasudag, GR 128822, when the accused was brought to the station and made to sign the confiscation of the marijuana report, he was already under custodial investigation. How about in a police lineup? A police lineup is not considered a part of any custodial inquest because it is conducted before that stage of investigation is reached. People versus Bravo, 135562. People versus Amistuzo, GR 104383, reiterates this rule because in a police lineup, the process has not yet shifted from the investigatory to the accusatory stage, and it is usually the witness or the complainant who is interrogated and who gives a statement in the course of the lineup. In People versus Piedad, GR 131923, it was held that the right to counsel accrues only after an investigation ceases to be a general inquiry into an unsolved crime and commences an interrogation aimed at a particular subject who has been taken into custody and to whom the police would now propound questions. Thus, in People versus Dagpin, GR 149560, where 3 eyewitnesses identified the accused at the police station as the person who shot the victim at the scene of the crime, the accused cannot claim that he was deprived of his constitutional rights even if he was without counsel at the time, because he was not yet then under custodial investigation. However, in People versus Custodial, where the accused, having become the focus of attention by the police after he had been pointed by a certain Rami as the possible perpetrator of the crime, it was held that when the out-of-court identification was conducted by the police, the accused was already under custodial investigation. An out-of-court identification may be made in a show-up where the accused is brought face-to-face with a witness for identification, or in a police lineup, where the suspect is identified by a witness from a group of persons gathered for that purpose. During custodial investigation, these types of identification have been recognized as critical confrontations of the accused by the prosecution, necessitating the presence of counsel for the accused. This is because the result of these pretrial proceedings might well settle the fate of the accused and reduce the trial to a mere formality. Thus, any identification of an uncounseled accused made in a police lineup or in a show-up after the start of custodial investigation is inadmissible in evidence against him. Investigations not considered custodial interrogation. A person under normal audit investigation is not under custodial investigation because an audit examiner can hardly be deemed to be the law enforcement officer contemplated in the rule. Navarro versus Sandiganbayan. Because the court administrator is not a law enforcement officer, an investigation conducted by him does not constitute custodial investigation within the contemplation of the constitutional guarantee. Office of the Court Administrator versus Sumilang. An investigation conducted by the Civil Service Commission involving fake eligibility is not custodial investigation. Remolona versus Civil Service Commission, GR 137473. In Carlos Tenenge versus People, an administrative inquiry conducted by the employer in connection with an irregularity or anomaly allegedly committed by an employee is not custodial investigation. Thus, a written statement given by the employee during such inquiry is admissible in evidence In People versus Salonga, where after an audit, the accused was summoned to appear before the assistant accountant of bank, and in the course of the interview, accused admitted having issued the subject cashier's checks without any legitimate transaction. The written confession was held admissible in evidence inasmuch as the interview did not constitute custodial investigation. In Ladiana versus People, GR 144293, it was held that the counter affidavit submitted by the respondent during preliminary investigation is admissible in evidence because preliminary investigation is not part of custodial investigation. The interrogation by the police, if any, would already have been ended at the time of the filing of the criminal case in court or in the public prosecutor's office. In People versus Manzano, GR 86555, it was held that when an arrested person signs the booking sheet in an arrest report at the police station, he does not admit the commission of an offense nor confess to any incriminating circumstance. The booking sheet is no more than a record of arrest and a statement on how the arrest was made. It is simply a police report, and it has no probative value as an extrajudicial statement of the person being detained. The signing by the accused of the booking sheet in the arrest report is not a part of custodial investigation. In People versus Endino, the Supreme Court ruled that the admission of the videotaped confession is proper. The interview was recorded on video, and it showed accused unburdening his guilt willingly, openly and publicly in the presence of newsmen. Such confession does not form part of custodial investigation, as it was not given to police officers but to media men in an attempt to solicit sympathy and forgiveness from the public. There was no showing that the interview was coerced or against his will. However, because of the inherent danger in the use of television as a medium of admitting one's guilt, courts are reminded that extreme caution must be taken in further admitting similar confessions. Spontaneous statements, or those not elicited through questioning by law enforcement officers, but given in an ordinary manner, where the appellant verbally admits to having committed the offense, are admissible. People versus Guillermo, GR 147786. January 20, 2004, and reiterated in Benjamin de Salva versus People, GR 187725, January 19, 2011. So the rights guaranteed by this provision refer to testimonial compulsion only. People versus Pioneer. What rights are available under the Miranda doctrine? 1. To remain silent. If the suspect refuses to give a statement, no adverse inference shall be made from his refusal to answer questions. B. To competent and independent counsel, preferably of his own choice at all stages of the investigation. If he cannot afford the services of counsel, he must be provided one. The right to counsel is intended to preclude the slightest coercion as would lead the accused to admit something false. In Gamboa versus Cruz, the Supreme Court held that the right to counsel attaches upon the start of the investigation, that is, when the investigating officer starts to ask questions to elicit information and or confessions or admissions from the respondent. The lawyer, however, should never prevent an accused from freely and voluntarily telling the truth. People versus Inanuria. Indeed, as the officer of the court, it is an attorney's duty, first and foremost, to seek the truth. However, counsel should be able throughout the investigation to explain the nature of the questions by conferring with his client and halting the investigation should the need arise. The duty of the lawyer includes ensuring that the suspect under custodial investigation is aware that the right of an accused to remain silent may be invoked at any time. Thus, where the lawyer merely affixes his signature to the confession as saksi or as witness, and he testified that he had not assisted the accused when the latter was investigated by the police, the extra judicial confession is inadmissible in evidence. People versus Peralta. When the accused is brought to the police station only to be identified by a witness, technically he is not yet under custodial investigation. Thus, in People versus Buntan, inasmuch as all that the police investigator did was to show the suspect the victim's sister and the latter's sworn statement identifying him as one of the two suspects in the killing, and the police had not started questioning, interrogating, or exacting a confession from the suspect, the right to counsel may not yet be validly invoked. However, in People versus Bolanos, where while being conducted to the police station on board the police ship, the accused made an extrajudicial confession that he had killed the victim. Inasmuch as the uncounseled confession was the sole basis of the judgment of conviction, it was held that the trial court committed a reversible error. While on board the police jeep, the accused was deemed to have been already under custodial investigation and should have been informed of his rights. In People versus Lucero, the court held that the petitioner was denied the right to counsel, where the lawyer, not counsel of choice, arrived at the CIS headquarters around 9 p.m. The second night of appellant's detention, talked to the appellant about his rights, left the appellant in the custody of CIS agents during the actual interrogation, and then came back the next day for examination and signature of the statement of the appellant. A similar conclusion was reached in People versus Moriel, where the lawyer left after about 30 minutes from the start of the investigation with instructions that before the accused signs any extrajudicial statement, it should be shown to him first. Indeed, as held in People versus Bermas, the mere pro forma appointment of a counsel de officio who fails to genuinely protect the interests of the accused merits disapprobation. In People versus Bandula, the Supreme Court stressed that the Constitution requires that the counsel be independent. Obviously, he cannot be a special counsel, public or private prosecutor, counsel of the police, or a municipal attorney whose interest is admittedly adverse to the accused. As legal officer of the municipality, it is seriously doubted whether a municipal attorney can effectively undertake the defense of the accused without running into conflict of interest. In People versus Juanario, it was held that there was a violation of this provision where the counsel assisted the accused in the custodial investigation conducted by the NBI was an applicant for employment with the NBI, as he, in fact, joined the NBI a few months later. In People versus Espanola, the Supreme Court declared that the city legal officer was not an independent counsel within the purview of the constitutional provision. Neither the mayor be considered an independent counsel because as mayor, his duties were inconsistent with his responsibilities to the suspect. However, the mere fact that the lawyer was a retired member of the judge advocate's office does not cast any doubt on his impartiality in assisting the accused during custodial investigation. People versus Hernandez, GR 117, 629. The phrase preferably of his own choice does not convey the message that the choice of a lawyer by a person under investigation is exclusive as to preclude other equally competent and independent attorneys from handling the defense. Otherwise, the tempo of custodial investigation will be solely in the hands of the accused, who can impede nor obstruct the progress of the interrogation by simply selecting a lawyer who, for one reason or another, is not available to protect his interests. People versus Baracina. Thus, in People versus Espiritu, it was held that the right to counsel does not mean that the accused must personally hire his own counsel. The constitutional requirement is satisfied when a counsel is engaged by anyone acting on behalf of the person under investigation, or appointed by the court upon petition by said person, or by someone on his behalf. While the choice of a lawyer in cases where the person under custodial interrogation cannot afford the services of counsel, or where the preferred lawyer is not available, is naturally lodged in the police investigators, the suspect has the final choice, as he may reject the counsel chosen for him and asks for another one. A lawyer provided by the investigators is deemed engaged by the accused when he does not raise any objection against the counsel's appointment during the course of the investigation, and the accused thereafter subscribe to the veracity of the statement before the swearing officer. People versus Duress. But in People versus Alberto, where the accused was not asked whether he wishes or can afford to retain his own lawyer, but was merely told that attorney Simafranca was a lawyer and asked if he needed his service, it was clear that he was not made aware that he could choose his own lawyer other than the one assigned by the police. What happens to the confession obtained after charges had already been filed? In People versus Española, the policeman brought accused Pakingan to the prosecutor's office as the accused manifested his desire to confess. But when the notes were transcribed, accused refused to sign, and only the lawyers who assisted him signed the confession. It appeared, however, that when the prosecutor took the confession, an information for rape with homicide had already been filed against Pakingan and his co-accused. Although Pakingan was no longer under custodial investigation when he gave his confession because charges had already been filed against him, nonetheless, the Supreme Court said that the right to counsel still applies in certain pretrial proceedings that are considered critical stages in the criminal process. Custodial interrogation before or after charges have been filed and non-custodial interrogation after the accused has been formally charged are considered critical pretrial stages in the criminal process. In People versus Nicandro, the Supreme Court said that this contemplates the transmission of meaningful information rather than the ceremonial and perfunctory recitation of an abstract constitutional principle. In People versus Canela, the Supreme Court, reiterating the foregoing, said that making the accused read his constitutional right is simply not enough. The prosecution must show that the accused understood what he read and that he understood the consequences of his waiver. In People versus Agustin, it was held that the right to be informed carries with it the correlative obligation on the part of the investigator to explain and contemplates effective communication which results in the subject understanding what is conveyed. Since it is comprehension sought to be attained, the degree of explanation required will necessarily vary and depend on the education, intelligence, and other relevant personal circumstances of the person under investigation. In People versus Sayabok, the court said that the right to be informed should allow the suspect to consider the effects and consequences of any waiver he might make of his rights. More so, when the suspect is like Sayabok, who has an educational attainment of grade 4, was a stranger in Nueva Vizcaya and had already been under the control of the police officers for 2 days previous to the investigation, albeit for another offense. Rights cannot be waived except in writing and signed by the person in the presence of his counsel. RA 7438 provides that any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing and signed by such person in the presence of his counsel, or in the latter's absence upon a valid waiver, and in the presence of any of the parents, older brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. Before I continue, just taking a quick break and reminding you to make sure you are subscribed to our channel, and you can download this if you want to listen to it while offline, but be sure to let some ads play as it helps fuel our channel. Thanks. No torture, force, which vitiates the free will shall be used, where the appellants did not present evidence of compulsion or duress or violence on their persons, where they failed to complain to the officers who administered the oaths, where they did not institute any criminal or administrative action against the alleged intimidators, formal treatment, where there appeared to be no marks of violence on their bodies, and where they did not have themselves examined by a reputable physician to buttress their claim. All these should be considered factors indicating voluntariness of confessions. There are two kinds of involuntary or coerced confessions treated in this section. Namely, 1. Coerced confessions, the product of third-degree methods such as torture, force, violence, threat, and intimidation, which are dealt with in paragraph 2, and B. Uncounseled statements given without the benefit of the Miranda warning, which are the subject of paragraph 1, People v. Vallejo, GR 144656. The alleged infringement of the constitutional rights of the accused during custodial investigation is relevant in material only, where an extrajudicial confession or admission from the accused becomes the basis of conviction. National Bureau of Investigation versus Judge Ramon Reyes. In People v. Andam, GR 116437, the Supreme Court held that the voluntary but uncounseled confession of the accused to the mayor and to the media was admissible in evidence. In this case, it was noted that it was the accused who freely, spontaneously, and voluntarily sought the mayor for a private meeting, and the mayor did not know that the accused was going to confess his guilt. Accused talked with the mayor as a confidant, not as a law enforcement officer. The confession made by the accused to the news reporters was likewise free of undue influence from the police authorities. The news reporters acted as news reporters when they interviewed the accused. They were not acting under the direction and control of the police. Constitutional procedures on custodial investigation do not apply to the spontaneous statements not elicited through questioning by the authorities, but given in an ordinary manner whereby the accused orally admitted having committed the crime. This is reiterated in People v. Dumantay, GR 130612, where the Supreme Court said that the oral confessions made to newsmen are not covered by Section 12, Article 3. The Bill of Rights does not concern itself with the relationship between a private individual and another individual. Rather, it governs the relationship between the individual and the state. The prohibitions therein are addressed primarily to the state and its agents. As to the requirement that the extrajudicial confession must be corroborated by other evidence, the court said that there was the corpus delicti, which corroborated the extrajudicial confession. Likewise in People v. Ordonio, the taped interview taken by the DZNL radio announcer offered as part of the testimony of the said announcer, where admissions were made by the accused when even expressed remorse for having committed the crime was admitted in evidence. On the strength of such testimony, the accused were convicted. In People v. Abulencia, the confession made by the accused in a taped radio interview over radio bombo was held admissible in evidence, and it was not shown that said reporter was acting for the police or that the interview was conducted under circumstances where it is apparent that the suspect confessed to the killing out of fear. Similarly, in People v. Maingan, the court held that when the accused appellant was brought to the barangay hall in the morning of January 2, 2001, she was already a suspect in the fire that destroyed several houses and killed the whole family of Roberto Cepeda Sr., and thus the confession of appellant given to the barangay chairman, as well as the lighter found by the latter in her bag, is inadmissible in evidence. But the testimony of Mercedita Mendoza, a neighbor of Roberto Cepeda Sr., on the same confession is admissible in evidence and is not covered by the exclusionary rule. In People v. Suela, January 15, 2002, the letter containing incriminatory statements was written when the accused was no longer under custodial investigation, and in open court, the accused admitted that he wrote it. The exclusionary rule will not apply to spontaneous statements not elicited through questioning by the authorities. How is the waiver done? It must be in writing and made in the presence of counsel. Section 12, Article 3, People versus Tunday. And it has no retroactive effect. The doctrine that an uncounseled waiver of the right to counsel and to remain silent is not to be given any legal effect was initially a judge-made one and was first announced on April 26, 1983 in Morales v. Ponce and Rile and reiterated in March 20, 1985 in People v. Galli. While this doctrine eventually became part of Section 12, Article 3, the requirements and restrictions therein have no retroactive effect and do not reach waivers made prior to April 26, 1983, the date of promulgation of Morales v. Sandigan-Bayan. Filoteo v. Sandigan-Bayan. Burden of proof. The burden of proving that there was valid waiver rests on the prosecution. The presumption that official duty has been regularly performed cannot prevail over the presumption of innocence. People v. Jara. People v. Taruk. Thus in People v. Paule, where the police officer could not state positively whether the lawyer assisting the accused provided him with effective counsel during the crucial aspects of the investigation, because the police officer went out of the investigation room and heard only snatches of the conversation between the lawyer and the accused, and the lawyer was not presented as witness during the trial. The Supreme Court held that the confession given by the accused was not admissible in evidence. The right to remain silent and the right to counsel, but not the right to be informed of these rights, may be waived. In People v. Mahinay, the Supreme Court laid down the guidelines and duties of arresting, detaining, inviting, or investigating officers or his companions as follows. The person arrested, detained, invited, or under custodial investigation must be informed in a language known to and understood by him of the reason for the arrest, and he must be shown the warrant of arrest, if any. Every other warning, information, or communication must be in language known to and understood by said person. He must be warned that he has a right to remain silent, and that any statement he makes may be used as evidence against him. He must be informed that he has the right to be assisted at all times and have the presence of an independent and competent lawyer, preferably of his own choice. He must be informed that if he has no lawyer or cannot afford the services of a lawyer, one will be provided for him, and that a lawyer may also be engaged by any person in his behalf, or may be appointed by the court upon petition of the person arrested, or one's acting in his behalf. That whether or not the person arrested has a lawyer, he must be informed that no custodial investigation in any form shall be conducted except in the presence of his counsel, or after a valid waiver has been made. That the person arrested must be informed that, at any time, he has the right to communicate or confer by the most expedient means, that is, by telephone, radio, letter, or messenger with his lawyer, either retained or appointed, any member of his immediate family, or any medical doctor, priest, or minister chosen by him, or by anyone of his immediate family, or by his counsel, or be visited by, confer with duly accredited national or international non-government organization. It shall be the responsibility of the officer to ensure that this is accomplished. That he must be informed that he has the right to waive any said rights provided it is made voluntarily, knowingly, and intelligently, and ensure that he understood the same. That in addition, if the person arrested waives his right to a lawyer, he must be informed that it must be done in writing and in the presence of counsel. Otherwise, he must be warned that the waiver is void even if he insists on his waiver and chooses to speak. That the person arrested must be informed that he may indicate in any manner at any time or stage of the process that he does not wish to be questioned, with a warning that once he makes such indication the police may not interrogate him if the same had not yet commenced, or the interrogation must cease if it has already begun. The person arrested must be informed that his initial waiver of his right to remain silent, the right to counsel, or any of his rights does not bar him from invoking it at any time during the process, regardless of whether he may have answered some questions or volunteered some statements. That he must also be informed that any statement or evidence, as the case may be, obtained in violation of any of the foregoing, whether inculpatory or exculpatory, in whole or in part, shall be inadmissible in evidence. And the exclusionary rule is confession or admission obtained in violation of Section 12 and Section 17, Article 3 shall be inadmissible in evidence. Waiver of the exclusionary rule for failure of the accused to object to the offer in evidence. The uncounseled confession was admitted in evidence. People v. Samus, GR 135957-58. So the next audio will be on bail. Make sure to turn on that bell after you subscribe to get notified when I uploaded it. Thanks.